Morning, everyone. So it's September 11th, 19 years ago. I'm sure we all remember where we were and what was going on. And I send out thoughts and prayers to those who lost loved ones on this particular day and to those who still struggle with what occurred at that point. Ironically, um, today is the 6 month anniversary of when the World Health Organization declared that we were in a pandemic. So we've made it through 6 months. There have been over 900,000 deaths that have occurred due to COVID. Um, and it's actually a lead in then to my topic for today. I hate to be so somber, but we're going to talk about estate documents and what happens if you die without a will. I'm going to thank Christina because she gave me this idea earlier this week because we were talking about making plans. And estate documents can be part of your plan. For those who don't have estate documents, just know that if something happens to you, the state in which you're considered to be domicile or your state of residency is going to take over and make decisions about how your assets are going to be transferred. So I think it's important that you know what's involved in having good documents drafted. And also, due to the fact of us dealing with the pandemic, you may have picked up on an article that I posted oh, 3 or 4 months ago now about estate documents and how important healthcare power of attorneys are right now. So let's take a step back and first discuss what happens if you pass away and you don't have any documents drafted or you don't have anything outlined as far as what you'd like to have accomplished. So as I mentioned, the state, they call this process intestate. And I'm going to speak on behalf of two states right now and give you some ideas on what would happen there. But every state is different, and so you need to investigate it if you're outside of these two particular areas. So in the state of Pennsylvania, if you pass away and you are a single individual, the first thing they're going to do is look at your family dynamics. If your parents are living, then your assets are going to go to your parents. If your parents are not living, then it's going to go to your siblings. If there are no siblings, they're going to then pass one half to your parents' situation. So it's going to go one half to any family members on your mom's side and one half to any family members on your dad's side. If you're married and you pass away, there's a couple of different scenarios. First of all, if you have a spouse but no children and no parents, everything goes to your spouse. If you have a spouse and your parents are still living, $30,000 goes to your spouse, and then one half of the remaining assets goes to your spouse, and one half goes to your parents. If you have children and a spouse, 30,000 goes to your spouse, and one half goes to the spouse, and one half goes to the children. And then we break down into if a child has passed away and there are grandchildren, then it would go, their share would go on to the grandchildren. Um, and then this similar scenario, if you're single without a spouse or children, then we're going to look to one half of your mom's estate, one half of your mom's heirs, and one half of your dad's heirs. Um, and it's interesting because the fact that the spouse doesn't receive everything if there's children, and you also want to be concerned about if your children are under the age of 18, because those assets would go into a trust on their behalf, and you don't have any control over who the trustee is going to be named in that situation. Your spouse can step in and say what they'd like to have happen, but it actually goes through the court system and they determine who's going to be the trustee. And at age 18, your child will get whatever share isn't they're entitled to. Now, these are for assets that don't have beneficiary designations. So, what assets are those? Those would be um, life insurance, it would be annuities, and it could be retirement accounts. Usually, you name beneficiaries associated with those. And then when you pass away, um, everything else or the beneficiaries designation supersedes anything else that is written anywhere else. So, um, you could have a charity name to receive those assets. Even if you had a spouse and children, the charity is going to receive those assets. So that's something to also consider is that that's how that passes. There's also legal entity names to assets. Some of you may have heard the terminology of joint tenancy. So there's joint tenancy with right of survivorship, there's joint tenancy with entirety, um, and there's also language that says uh, TOD, which is transfer on death, or POD, which is passes on death, that you can actually name accounts in with this titling, and it will then determine how those assets are going to pass as well. The other state I just wanted to briefly mention is the state of New York, because Christina had asked me specifically about New York and what happens there. So the situation is actually very similar to what happens here in Pennsylvania. So if you're a single individual, um, they're going to first look at, did you have any children? And it's going to pass to the children. It's going to go in equal shares. If you had a spouse, whereas Pennsylvania uses the 30,000 as far as what the spouse keeps, New York actually uses 50,000. So 50,000 would go to the spouse, and then the remaining would be divided between the spouse and the parents, or the spouse and the children. And the children would receive it equally if there wasn't a spouse, and then we go on to parents, then we go on to siblings, and then pass according to um, mom and dad's situation. Now, in both the state of Pennsylvania and the state of New York, if there are no surviving heirs, then it's going to go back to the state. The state actually assumes the assets from that standpoint. So I just wanted to point that out as far as what happens in New York. So let's go back to the documents. So first of all, let's talk about a will. And a will is basically outlining how those assets would pass that you haven't assigned a beneficiary designation or you haven't put a legal titling on. So traditionally, any assets passing through a will would have to go through a process called probate. And I'm going to hit all the technical aspects of this, and I'm going to share some stories with you at the end of the video. As far as my experience in going through probate and my experience on having people that have passed without a will. So in the will, you can also create a trust. And a trust would then give the trustee within the will the um, instructions on how they want the assets to be handled. I do see many times that a trust is created within a will that will outline how the assets will pass to children. So many times when you have a family that has children under the age of 18, they create this trust inside of it that will outline when the children will receive what. Many times the assets go directly to the spouse, and then if something happens to both of them, a trust can be set up so that at 18, the child doesn't receive everything. That maybe they receive a portion of it at age 18, a portion at age 21, a portion at 25, another portion later in life. And depending upon your family dynamics and your comfort level with your children being able to handle potentially large sums of money, that might be important for you to identify within the will. The will also will identify who that trustee will be. They will also identify who the executor would be. So the executor is the person who is responsible for processing the will, making sure that the assets are distributed, and then once everything is completed, their job is done. So an executor, which is the terminology used for a male, and executrix is the terminology used for a female, are outlined within the will. And usually that role only lasts let's say 2 to 5 years, depending upon the complexity of the situation. Then we also have the trustee. A trustee's role can actually last for an extended period of time. So especially if you're creating a trust for children, let's say the children at this age, let's say both the parents pass away and their ages 5 and 8, that trustee may have that responsibility of overseeing and managing that money for many decades to come, depending upon what language is written in there. Okay. Um, The beneficiaries also might be addressed within the will. You may name who your living children are. This is important to identify as well because I've seen situations where parents have wanted to leave out a child from receiving a share of their or a share of their assets, and they actually outline that within the will. So maybe they have a child that has fallen off from the family, has discommunicated, or for whatever reason they don't want to leave any funds to them. Or maybe they have done financially well for themselves and they want to provide for other children that might benefit more. You really want to identify that in your will. One of the reasons being is that after the fact, you don't want anybody to contest the will and say, well, you know what, mom and dad didn't name me. I really am entitled to that. Maybe they just forgot. By naming them and identifying the fact of why you are not including them in the document, will tell the courts that, yeah, you did you did recognize that they were there and why they weren't included. So that's just the basics in regard to wills. I'd also mention powers of attorney. So power of attorney is when you release control over making certain decisions. There can be powers of attorney for healthcare, and there can be powers of attorney for financial situations. And some attorneys write those documents together, some attorneys do not. And it's up to a personal preference from your standpoint because, for example, if you needed a healthcare power of attorney, you wanted to share that with your doctor that allows somebody else to make decisions regarding your situation. If you were in surgery or if you had a health issue arise that you couldn't communicate at that point what you would like to have done, they may have to submit both the healthcare and the financial power attorney together to that doctor. Maybe you don't want them to see both of that. So many times they're actually writing them separately now. Now, the healthcare power of attorney can be very valuable, especially right now as we're dealing with the pandemic, because if you have individuals who are now being put on a ventilator and they have the healthcare power of attorney, this is going to give the opportunity to the doctors to communicate with whomever you've named as your agent in the healthcare power of attorney about your situation and be open and communicate. Whereas right now, with the HIPAA laws that are out there, the doctors really do not have to um, share information with anybody, including your spouse, unless you have a signed power of attorney for them to do this. So they can be very valuable. The other thing I want to point out with them is that they are state specific. So if you are in a state of domicile, you want to have your documents written according to the state that you consider to be your home state. And many other states will honor that language, but they all of them have little different tweaks that go along with them. So it's important to know that too. Now, there's also the financial power of attorney, and I haven't seen that used very often, with the exception of when it came to buying and selling real estate. There have been situations that I've experienced where a spouse could not be available for the closing on a property, whether it was buying or selling, and the spouse was able to take the power of attorney with them to act on that spouse's behalf if, for whatever reason they were traveling, they were out of the country, but they agreed to have the spouse work with this power of attorney. And then powers of attorney have two different methods in which they come into effect. One is called a springing power of attorney, and one is called a durable. Once a durable power of attorney is signed, it is live and it can be acted upon at any time. A springing power of attorney means that a certain event had to occur, um, some type of a trigger point that would make the power of attorney go into effect. So that's important to understand as well. So a fourth type of document that are very important to know is a living will or an advanced healthcare directive. And a living will is one that goes into effect when a certain event has occurred. For example, if someone is in a coma, if they're at end of life, um, the advance directive is giving directions on what that person wanted to have occur. So this would be things like, did they want a feeding tube? Did they want life support? Did they want someone to try to revive them if they're in that type of a situation? So a living will, a advanced healthcare directive is very important as well. Some of you may remember a very popular event that occurred with the power of attorney, Terry Schiavo, and the husband wanted a certain um, event to happen. Her parents wanted a different event to happen, and the power of attorney would have superseded all of that and would have told the doctors how to handle the situation. Um, so those are the four main documents when it comes to estate planning. There are many other kinds of documents that can aid in a situation when it comes to estates. There are different kinds of trusts that can be created. There are revocable versus irrevocable trusts. I'm not going to get into all of that today. I was going to try to keep this a little bit shorter, but I know, I just want to keep your attention and hopefully let you touch on those types of documents and think about them for a minute. There are actually online websites that you can create the documents. There are attorneys who specialize in this, which I always recommend working with an attorney who specializes in estate documents. I'm going to start sharing some of my personal experience. I had a husband and wife who were here in the state of Pennsylvania. They wanted their estate documents to be drafted, but they chose Joe down the street, and Joe's area of expertise was real estate deals. And the husband and wife had a lot of assets inside of retirement plans, and their estate at this point would have incurred a lot of federal estate taxes if it was not handled properly. And so I suggested to them that they have the language within their will drafted so that their um, retirement assets could be passed appropriately so that they would not be included within the federal estate taxation realm at that point. And so when they went to the attorney and they said, this is what our assets look like, we want to take advantage of this, the attorney had no idea what they were talking about. He actually came back to me and asked me for the language, which I do not practice law, nor do I have any right to share that information. Um, of what I've seen with other documents and other clients' documents. And I told the clients, I'm like, you can't work with him. He doesn't understand your situation, and he's not going to be able to give you the best language out there to take advantage of what was going on in the world today. Now, right now, an individual can pass over $11 million federally estate tax free. So, so a lot of people don't need that language any longer, but there are some really unique techniques that can be put into documents to make sure that assets are protected and they're passed according to your wishes. And only a knowledgeable estate planning attorney is going to be able to do that for you. Um, Another situation I wanted to share with you was I had a client whose the husband passed away in this situation, and I actually went through the probate process with the wife. We met with the attorney, and in this situation, we went down to the Allegheny County Courthouse, and she was sworn in as the executor. When you're sworn in as the executor, you actually receive a certificate that states that, which that certificate then can be shared with outside entities that hold the assets that the husband had actually had. So we made sure that we had enough of these certificates so that we could address all the investment accounts. We needed one for the bank because he had safety deposit boxes, and that's another part of the story. But once she was sworn in, then she could go back and start to handle the situation and distribute the assets. One of the things that she found when she went back to the bank, and some of you may be aware that the banks will not just open up a safe deposit box if somebody has died and their name's on that box. So you need to have this affidavit that says you're the executor. Well, when she opened up the first safe deposit box, which was the only one that she thought that they had, she found that there was a key for another safe deposit box. She proceeded through this process, and there was actually four safe deposit boxes that she was not aware of. Now, the husband had been an avid stamp collector, and in each one of these boxes, he had more and more of his stamp collection. Well, what was interesting with this was that the contents of the box had to be identified by a bank. In this case, it was the bank manager, and they had to create an inventory, which became part of the process for probate as well. And each of these books of stamps had to be included in the process, and we had to find a individual who could examine the stamps and give a relatively reasonable valuation on the stamps, and they had to go through the probate process as well. So it's interesting. Had these stamps just been in the closet at home, process would not have been involved there. We wouldn't have had to hire somebody. Um, but in this case, it was identified and needed to be put through the whole process. So that was an interesting event for myself, and it was a learning experience. The other thing is with your wills, you don't necessarily want to identify those personal properties. I had a situation where the client lived in Texas, and one of the first paragraphs of his will was he was identifying all of his firearms and which children he wanted to receive his firearms. Well, the other aspect about a will is once it's submitted to probate, it becomes public knowledge. And so if that went through the process, now anybody could walk into the courthouse, ask to see Joe's will, and could identify that those firearms did exist. Um, so we worked through that. We actually created a separate document that wasn't a will or a power of attorney or anything that had to go through the court system. It was a separate memorandum that identified those personal properties and how he wanted those to be split. And we got them out of the will. I had another scenario a number of years back, now that we're in an election year. If you remember, Teresa Heinz um, was married to a presidential, or is still married to, he was at the time a presidential candidate. And the local newspaper came back to me and asked me if I would go through her ex-husband or her deceased husband, John Heinz's will, and identify what property she may have received in light of that situation. Well, as you can imagine, the Heinzes were a wealthy family and obviously did things correctly. As I read through the will, all the personal property passed through a trust. There was nothing that was identified, and the trust was kept outside of the will, didn't have to go through the probate process, and there was no way for anyone to identify whether she inherited um, artwork or dollar amounts or other trusts. Everything was kept very private. So you have that opportunity too, is to keep things under lock and key. So I just thought I'd share some of those stories with you. Now I know a lot of us and that may be listening to this don't necessarily have those types of issues, and but if there are things that you want to be kept private, creating that trust within your will can be important as well. Just one other thing that I wanted to touch on in regard to this was the state of Pennsylvania actually has what's called inheritance tax. And so if any of your assets are passing to a spouse, there is no inheritance tax. If any assets pass to your children, there is a tax of 4.5% on those assets going to your children. If it's going to another family member, that amount goes up to 12%. And if it's going to another individual who you are not related to, it can be 15%. Any gifting made to a charity is at zero. But a lot of people don't realize that the state of Pennsylvania has what they call inheritance tax, and many states do not have inheritance tax. So it's important to, again, understand what your state um, puts as far as ramifications go on in the state. But I just thought I'd share that with you as well. So I covered a lot of different topics here. I encourage you to maybe listen to this more than once. If you have any questions, obviously give me a call at 412-346-4655 or send me an email at Diane, Diane, at Pearson, Pearson, financialplanning.com. So that's Diane at pearsonfinancialplanning.com. Once again, please share this with anyone you think might be in need of this information or have questions, and they can contact me. The other thing I should have mentioned this earlier, but your children, after the age of 18 are considered adults in the state of Pennsylvania, and you need powers of attorney for them as well. So the HIPAA rules go into effect, and you as a parent might not be able to get that information. And what's even more important is if they're away at school, you want to be able to communicate with the school, with the medical staff, if they're in the hospital. And the only way to do that is with a power of attorney. So thank you for spending your morning with me. I appreciate your time. And again, don't hesitate to reach out if you've got some questions. I'm happy to be that resource for you. Thanks. Have a great day.